Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be continuing with the Code of Civil Procedure. We have already done one lecture on CPC and today is our second lecture and we will be dealing with all the important questions of CPC, right? Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will be very helpful for your revision. It will include chapter-wise tests, sectional tests and full-length tests. And also we have come up with a live crash course for both the phases, phase 1 and phase 2. The live classes are already going on. It also includes the test series and it also gives you one-on-one mentor support. We will be dealing with all the subjects that are mentioned in your syllabus and we will be focusing on the securities and companies law, as it forms a very important part of your phase 2 examination. So we will be specially focusing on those subjects. So this will be very helpful to you for both the preparations for phase 1 also and phase 2 also. So those of you who are interested can refer to the link in the description below. Now let's start. First question number 1. Under the code, the provision of notice before instituting a suit against the government is given in, is it section 82, 80, 79, 78 or 84? The answer is option B, that is section 80. Section 80 talks about the procedure, that how can we initiate a suit against the government or a public officer. The theory of sovereignty does not apply in India. The king can do no wrong. It does not apply to India. So in that case, what happens is our government, it can sue and at the same time it can be sued. And we can also sue a public officer in his official capacity. But since here we are talking about the special circumstances, they are the government and they are the public officer doing some act in their official capacity. That is why a special provision has been made. A special procedure has to be followed, that we will be dealing with it. That what is this special procedure? They are special in nature and the procedure they follow, they are also special, right? So first of all, let's see what section 80 says. Notice. Save as otherwise provided in subsection 2, no suit shall be instituted against the government or against the public officer in respect of any act purporting to be done by such public officer in his official capacity. So they are saying these are the special circumstances in case of the government or in case we are instituting a suit against a public officer in his official capacity. This section does not apply if you have to institute a suit against a public officer in his private capacity. They are only talking about a suit that you have to institute against him in his official capacity, something he has done in his official capacity against that action only, right? So what they are saying is until the expiration of 2 months after the notice in writing has been delivered to or left at the office. So that means that 2 months notice has to be given to the government or the public officer if we want to institute a suit against them, right? So they are saying until the expiration of 2 months next after the notice in writing has been delivered to or left to the office, either it has been delivered or we have left the notice at their office. So they have to be given 2 months notice if we want to institute a suit against them. What is the purpose of section 80? It is to give notice, 2 months notice to the government or the public officer so that they can render, they can decide if the claimant is right in whatever he is claiming. So they can settle it, they can give him whatever he is asking outside the court, because it is in the interest of justice that there should be an end to litigation. And if they feel like the claimant is claiming the right thing, they can accept the claims of the claimant and within these 2 months and there will be no litigation. So this is the purpose behind section 80, right? Let's read it again. Save as otherwise provided in subsection 2, no suits shall be instituted against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity. This section only applies when we are talking about his official capacity until the expiration of 2 months next after the notice in writing has been delivered to or left at the office. So it has to be a notice of 2 months. I hope this section is clear to you. Question number 2. Which provisions of the code provide for the exemption from arrest and personal appearance? So it is section 81, right? As I've told you that these are the special circumstances, these are the special suits. So special status has been given to them. Let's read what this section is saying. In a suit instituted against a public officer in respect of any act purporting to be done by him in his official capacity. They are only talking about their official capacity. The defendant shall not be liable to arrest nor his property to attachment otherwise than in execution of a decree. So he will not be arrested, neither his property will be attached unless we are talking about the execution. If it is in execution, then it is a different case, but without execution, he shall not be arrested and his property shall not be liable to be attached, right? So the defendant shall not be liable to arrest nor his property to attachment otherwise than in execution of a decree. And where the court is satisfied that the defendant cannot absent himself from his duty without determinant to the public service, it shall exempt him from appearing in person. So his personal appearance is also exempted if the court is satisfied that it will only harm his public service. So if the court is satisfied that it will harm the public service or it will be determinant to his public service, in that case they can exempt the presence, they can exempt the appearance of that public officer. I hope this section is also clear to you. Next question. Impleader suit may be instituted where one or more persons claim adversely to one another the same debts, where two or more persons claim adversely to one another the same debt, where three or more persons claim adversely to one another the same debts, or where five or more persons claim adversely to one another the same debts. The answer is option B, where two or more persons claim adversely to one another the same debts, right? Let's read it first. Where two or more persons, they are claiming adversely, that is against each other, the same debts, sum of money or other property. So they are if claiming the same thing, so they are claiming the same sum, the same money, the same property against each other, right? So where two or more persons claim adversely to one another the same debts, sum of money or other property, movable or immovable. So it can be movable also and it can be immovable also from another person. They are claiming that thing from one person, right? So they are claiming that thing from another person, from one single person who claims no interest, and that person who has that property, he claims no interest in that property therein other than for charges or costs. He is only going to be asking for the charges or cost and nothing, and no interest in that property, and who is ready to pay or deliver it to the rightful claimant. And he is saying that I am ready. Just let me know that who is the rightful claimant and I am going to deliver the property or the money to that person. Such other person may institute a sort of pleader against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made, and of obtaining indemnity for himself. So what is happening here is that that person who has that property, he is going to institute a suit, and that suit is known as interpleader suit. He is going to ask the court, just let me know that who is the rightful claimant so that I can deliver this property or I can deliver this money to that person who is the rightful claimant, and also to indemnify him for future, right? So no one in future is going to come against that person and ask him that that property belongs to me. So he's asking for two things. First of all, let me know that who is the rightful claimant, and the other thing, that protect me for the future claims as well, right? Protect me from the future claims also. So let's understand this. For example, if we talk about the ordinary cases, what happens is there is a plaintiff and there is a defendant. What happens in an ordinary suit is that one person alleges something and one denies it. But in interpleader suit, what happens is that one person, he is ready to pay. He is saying, I know that I have this debt. I know that I have this property and it does not belong to me, or I have this debt that I have to pay. Just let me know that who is the rightful claimant. I don't know who I have to give that property to, right? For example, the plaintiff is ready to pay and there are 4 or 5 defendants, and all of them, they are claiming that this thing is mine and this thing is mine. So in that case, what is the plaintiff, what is the person who has that property is going to do? He is going to institute a interpleader suit, right? And in that interpleader suit, he is going to ask the court and he is going to ask the court, just let me know that who is the rightful claimant so that I can deliver this property to that person, and at the same time also indemnify me from the future liability, from any future liability that may arise. So this is what this is known as interpleader suit, right? Let's read it again. Now it will be clear to you. Where two or more persons claim adversely to one another the same debt, sum of money or other property, it can be movable or immovable, from another person who claims claims no interest. So he knows that I don't have any interest in such property therein other than for charges or cost. But he is only going to claim charges or cost that may have occurred to him. Either it can be for the institution of suit or any other charge that have occurred to him, right? And who is ready to pay or deliver it to the rightful claimant. Such other person may institute a suit of interpleader against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made. So he is just asking, let me know that who is the rightful owner, and of obtaining indemnity for himself. Provided that where any suit is pending in which the rights of all the parties can properly be decided, no such suit of interpleader shall be instituted. So, for example, there is already a suit going on, and with the help of that suit, the rights of all the parties, they are going to be decided. So, in that case, if such a suit is pending, then an interpleader suit is not going to be instituted. This is what the proviso is talking about, right? So, provided that where any suit is pending in which the rights of all the parties can be properly decided, no such suit of interpleader shall be instituted. Question number 5. The defendant against whom an ex parte order has been passed can prefer an appeal under. So the answer is option C, that is section 96(2). So here we are talking about appeal, right? Only in CPC you have the provision of second appeal. So please remember, it is only in CPC that provides you with the second appeal. So here we are talking about the first appeal in section 96. Your first appeal is always a matter of right, right? It is always a matter of right, and no one can take away it from you except the statute. So it is what? It is a statutory right. Okay? Always remember that first appeal is your statutory right. Right? So let's read this section. 96. Save where otherwise expressly provided in the body of this code or by other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction. So it is a matter of your right. Appeal shall lie from every decree, right? It is going to apply from every decree passed by any court, every decree and any court exercising original jurisdiction. So that is why I have told you that your appeal, your first appeal is always the matter of right. Appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. It will lie before such court who has been authorized, right? So let's read it again. Save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. Subsection 2, an appeal may lie from an original decree passed ex parte. So if a decree has been passed ex parte, that is without the defendant, then also such decree is what? It is appealable, right? So an appeal may lie from an original decree passed ex parte. No appeal shall lie from a decree passed by the courts with the consent of the party. So what they are talking about is, if it is a consent decree, what is a consent decree? A compromised decree, right? If it is a compromised decree where they compromised in that decree, right? So they agreed to some terms, and that terms they were authorized by the court. In that case, what happens is they get a compromised decree, or as we say, consent decree, right? So in a consent decree or a compromised decree, what happens is that there are two parties and they agree to a one single thing and they come to a settlement, and that is approved by court. The court is only authorizing that. The court is only the stamping authority in that case, and in that case, when they both agree to that compromised decree, an appeal shall not lie. But there is also an exception to that case. For example, one party alleges that my consent was taken by fraud. In that case, an appeal can lie. But otherwise, in a compromised decree or consent decree, an appeal shall not lie. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by the court of small causes. They are talking about the small causes court. So the small causes court is only going to prefer an appeal, is only going to hear an appeal if it is on the question of law. And there is one other condition: when the amount or value of the subject matter of the original suit does not extend 10,000 rupees. So if you have to file an appeal to the small causes court from an order of the small causes court, there are two conditions. First, it is only going to be on the question of law, and the second one is that the subject matter that you are talking about, it should be more than 10,000 rupees, right? Let's read it. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by courts of small causes when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. Question number 6. Which of the following statement is true about section 100? An appeal may lie under section 100 from an appellate decree passed ex parte. In an appeal under section 100, it is not necessary that the substantial question of law involved in the appeal is stated in the memorandum of appeal. Where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. The answer is option C, that is first and the third statement. They are only correct. Let's read section 100. Now we have come up to the second appeal. Second appeal is always heard by the High Court. It is always filed before the High Court. Let's read section 100. What does it say? Save as otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to High Court. So they are only talking about the second appeal, and it lies where? It lies before High Court. From every decree passed in appeal. So from the decree that has been passed in appeal by the court subordinates to the High Court. It has to be from a decree that has been passed by the appellate court, right? So where it has been passed by an appellate court, there the High Court is going to come into picture. If the High Court is satisfied that the case involves a substantial question of law. But now here, the scope of this appeal, it has been narrowed down, right? It is only when the High Court is satisfied that it involves a substantial question of law, right? Any appeal may lie under this section from the appellate decree passed ex parte. It can also lie when it is from an appellate decree that has been passed ex parte. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. So in the second appeal, you have to mention in your memorandum, you have to mention it precisely, very accurately, that what is that substantial question that you want to raise, right? So this is what they are saying. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Where the High Court is satisfied that substantial question of law is involved in any case, it shall formulate the questions. And if the High Court is satisfied that yes, this question, it is a substantial question of law and that it needs to be decided, then in that case, what the High Court is going to do, it is going to formulate the question in accordance with itself. They will formulate it with necessary changes, for example, right? So the High Court is going to formulate the questions here. The appeal where the High Court is satisfied that the substantial question of law is involved in any case, it shall formulate the question. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. Now the appeal is only going to be heard on that question of law, only the question of law that the High Court has formulated, right? So the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. Provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for the reasons to be recorded the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. So now, for example, in the course of argument, there comes up another question that they think that it is also a substantial question and it also needs to be decided, right? In that case, what is going to happen? The High Court is going to record such reasons. It is going to record it, and it will also hear the arguments on that question that was not formulated originally. It is also going to hear the arguments on another substantial question that it did not formulate, but it arose in the course of the proceedings, right? So this is what they are saying, that provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for the reasons to be recorded the appeal on any other substantial question of law not formulated by it, that was not formulated by it, but it arose, and that they are satisfied that the case involves such questions, that the case, it involves such questions, and it is also important to decide it, it is also substantial to decide it. So what will they do? They will decide that question also, right? Now the question arises that we have been talking about this substantial question of law, but what actually is a substantial question of law? Let's understand what all comes within the definition of the substantial question of law, right? So I will be quoting the Supreme Court here. So what is the test of substantial question of law? that it is fairly debatable and it does not have a precedent. So if it is fairly debatable and it does not have a precedent, then it is what? It is a substantial question of law. The second one is there is scope of different opinion. Third one, alternative views are equally possible. In a case where the alternative views, that is two opposite views, they are equally possible. In that case, it is what? It is a substantial question. The last one is the point is open and not finally settled by the court. If it is an open point, if it has not been decided, then in that case, it is what? It is a substantial question of law. I hope this is also clear to you. Moving on, question number 7. Which of the following Amendment Act added section 100? And the answer is option B, that is 2002 Act, right? So the amendment that added the section 100A was the Civil Procedure Code Amendment Act 2002. Next question. Second appeal shall not lie from any decree as provided under section 102 of CPC when the subject matter of the original suit is for the recovery of a money not exceeding. The answer is option C, that is 25,000, right? Let's read it. So, no second appeal shall lie from any decree when the subject matter of the original suit is for the recovery of money. They are only talking about a money suit when it is not exceeding 25,000 rupees. So if your subject matter, it is less than 25,000 rupees, in that case, no second appeal shall lie. Right? Next question. Which section of the code lays down the power of the High Court to determine an issue of fact? So now we have come to a section that talks about that an issue of fact, it can also be raised before the High Court. Till now we have only been discussing on the question of law, but there is a provision that talks about that the High Court is also going to hear your appeal in case it is a matter of fact and when it is going to be. So it is given in section 103, that is option C. So it is section 103 and the title reads as power of the High Court to determine the issue of fact, right? And they also talk about any issue. They have used the term in the section any issue, which means it can be of law also and it can be of fact also, right? So in any second appeal, the High Court may, if the evidence on record is sufficient, determine any issue necessary for the disposal of the appeal, which has not been determined by the lower appellate court or both by the court of first instance and the lower appellate court. So when such issue, it may be of law or it may be of fact, when it has not been determined, it has not been decided by either both the courts or either by the appellate court. In that case, that question of fact, it can be heard by the High Court, right? So which has not been determined by the lower appellate court or both by the court of first instance and the lower appellate court, or which has been wrongly determined by such court or courts by reason of decision of such question of law as is referred to by section 100. Or in a case where a question of fact has been wrongly decided. And why has been it wrongly decided? Because they have determined the question of law wrongfully, right? Because they decided that question of law wrongfully, that is why they have determined this question of fact also wrongfully, right? So which has been wrongly determined by such court or courts by reason of decision on such question of law as is referred in section 100. So in both these cases, a question as to the fact, an issue, any issue as to the matter of fact can be heard by the High Court if the High Court is of the opinion that such issue is necessary for the disposal of the appeal. For the complete disposal of the appeal, it is necessary that we have to determine that question also. It can be of fact also and it can be of law also. I hope section 103 is also clear to you. Moving on, question number 11. An appeal lies to the Supreme Court from any judgment, decree or final order in a civil proceeding of the High Court subject to the provisions in. It is option A, that is chapter 4 and chapter 5 of the Constitution, right? So section 109 states that the appeal to the Supreme Court under CPC are subject to the provisions in chapter 4 and chapter 5 of the Constitution. Question number 12. An appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceedings of a High Court if. The answer to this is E, that is both B and C are correct. That is, the High Court certifies that the case involves a substantial question of law of the journal importance, or the High Court certifies that the opinion of the High Court, the said question needs to be decided by the Supreme Court. Let's read section 109 and then it will be clear to you. An appeal shall lie to the Supreme Court. Talking about an appeal that lies before the Supreme Court. Any judgment, decree or final order in a civil proceeding of the High Court if the High Court certifies. So the only condition is that the High Court has to certify the judgment, decree or final order that the case involves a substantial question of law of journal importance, that the High Court has to certify that yes, that order, it involves a substantial question of law of the journal importance, right? And there is that is both these conditions, they have to be fulfilled. The second one is that in the opinion of the High Court, the said question needs to be decided by the Supreme Court. So the High Court is of the view that the Supreme Court should decide such question. In that case, the appeal can lie before the Supreme Court, right? So as you can see, the scope of appeal before the Supreme Court is even narrower, right? It is even narrower than it was in the High Court. It can only hear the appeal where the High Court is of the opinion, that where it certifies that yes, it is a substantial question of law, it is of a journal importance, and it needs to be decided by the Supreme Court. This section, it has to be read with Article 132, 133 and 136 of the Constitution, right? Okay, moving on, question number 13. The appellate court shall have the same power and shall perform as nearly as may be the same duties as are conferred and imposed by this court on. The answer is court of original jurisdiction. Let's read it. Subject as aforesaid, the appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by this section on the courts of original jurisdiction in respect of the suits instituted therein. So they will have the power, they will have the duties, same as the courts of the original jurisdiction, right? Next question. Which of the following sections are repealed from the Code of Civil Procedure? So section 110, 111, 111A, they have all been repealed, right? Question number 15. How many sections and orders are there in the Code of Civil Procedure 1908? The answer is option C, that is 158 sections and 51 orders. The code is divided into two parts. The first part contains 158 sections and the second part contains first schedule, which has 51 orders and rules. Now, question for achievers. As per Code of Civil Procedure, an appellate court shall have power to determine a case finally, to remand a case, to frame issues and refer them to trial, to take additional evidence or require such evidence to be taken, or all of the above. So you have to comment the right answer below. So that was all for today. I hope this was an helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.